Welcome to today's presentation with Jody Millman. We're going to talk about protecting your artistic rights. We are in the middle of Global Entrepreneurship Week, and so we have one more Global Entrepreneurship Week presentation tomorrow, and that is going to be it will be virtual on Zoom, and it's about making your small business more accessible. So if you'd like to join us for that, we'd love to have you. And for those of you who are online, if you have questions, you'll post them in the chat, and I will share them with Jody at the end. And for those of you who are here in the room with us, when we get ready for questions, just let me know what they are. I'll have you ask them to me. I'll repeat them so Jody and everyone online can hear them, and then Jody will answer them. So I'm going to start with introducing Jody. Jody Millman has won multiple awards for her novel, The Midnight Call, and is the best-selling author of Seats, New York Theater Guidebooks. She's an attorney, a reviewer for booktrib.com, the host producer of Backstage with the Bardavon podcast, and a creator of the Writers Law School. Her most recent book is Hooker Avenue, and she lives with her family in the Hudson Valley. So welcome, Jody. We're very happy to have you. I'm going to turn off my camera so you can do your presentation, but I'll be here in the background, and then we'll see you on the other side.
Okay, that sounds good. Well, thank you, Jennifer. I need to share the screen. Welcome to the Writers Law School, everybody. Hooray, we got it. Well, good evening. My name is Jody Millman. As Jennifer said, I am an attorney in New York. I'm also an author, podcaster. I wear a lot of hats. And I've been practicing law, I'm going to tell you, since 1979. And during that time, and when I was in law school, I was really interested in copyrights and trademarks and patents. So that is something that I've developed over the years. And recently, I would say over the past 10 years, as I became a writer, was writing fiction and nonfiction, I would be going to conferences and people would say to me, hey, I hear you're an attorney. So they would ask me questions. So I decided during lockdown that it might be a really good thing for me to create a program so I'm able to communicate to writers and artists how to protect their legal rights. So I'm excited to be able to share this information with you today. The program, as Jennifer said, runs about an hour, a little over an hour. Hopefully it's fast and fun. And then what we'll do is I'll take your questions and we'll go from there. So again, welcome to Writers Law School. In this presentation, we're going to be discussing several topics: intellectual property, copyright registration and the case registration, fair use, public domain, business entities, publishing contracts, and I don't think we're going to have time for censorship, but we'll talk about some other things. First of all, what is intellectual property? Intellectual property is divided really into three categories: copyrights, patents, and trademarks. What is the difference and what does each protect? Well, first we're going to start with copyright. Now, everybody knows what this little C with a circle, that's called the copyright bug. It's a designation which indicates a protection of original works of authorship. And you're entitled to protection and registration under the US copyright statute. Now, copyright protects such things as literary works, film, musical works, sound recordings, broadcasts, poems, podcasts, weaving, blogs. It covers a whole rainbow of artistic works, which can either be written, they can be sound or motion picture. Now, who is a copyright owner? A copyright owner is the author. That is the person who creates the original work of authorship. Now, what that means is from the moment you put your pen on a piece of paper or your fingers on the keyboard, you are an author, unless you are a work for hire. And I'm going to be talking about that in a few minutes down the line. One thing that's important to remember is that merely coming up with an idea does not make you an author. And I have to thank the New York State Bar Association because they had these wonderful slides that I have borrowed because I took a class in copywriting, graphic novels, and comic books. And these little slides really seem to hit home. So you'll see as we go through the presentation that I've incorporated quite a few into my work here. Oh, wrong way. Okay. Now, what are some of the key rights that are contained within copyright? Well, the right to copy. That means that if you write something or you do a picture, you have the right to make as many copies as you want. You have the right to distribute it, which means you could put it up on Amazon. You could do self-publishing, print your own books and distribute them. You could publicly perform them. So if you're doing a play or you're doing let's say you want to do a workshop or you're attending an open mic night, it gives you the right to stand up and read and perform and display your works. As I said, public display, for example, if you make a film, you're able to go ahead and display it, perform it. Again, if you write a song, you're able to publicly perform it. And also the derivative works and derivative rights are included within your initial copyright. Now, what is a derivative work? It's really interesting because I want you to think of copyright as a tree, and the trunk of that tree is the work that you create, and the branches that go out are all of the other works that flow off of your copyright. So for example, if you look at our little copyright golem here, you can make a comic book of him, a movie, TV show, a video game, or a toy. So if you write a book, you could make a movie, you could do a foreign interpretation of it, you could do a play, you could draw pictures about it. That is a derivative work. It's anything that flows off of your original work. And here's that little slide that says that the author is the owner of the copyright, except if you're a work for hire, and merely coming up with an idea doesn't make you a copyright owner. These are the key rights that are contained within copyright. It's the right to copy, the right to distribute, to publicly perform, publicly display, and derivative works. And then I talked about, we're catching up here, so we don't have too many. Now, this is a copyright golem, and in talking about the right of derivative works, as I said, I want you to think of copyrights as a tree. The trunk of your tree is your artistic work, and all of the branches that are going off it represent the derivatives and the works that flow from your initial work. And if you look at this slide, you'll see we have comic books, we have movies and TV, video games, and toys. And those are the things that we could make, for example, out of this copyright golem. And now we are back up to speed. Here we go. Merely coming up with an idea does not make you an author. So I want you to think about that in terms of the trope of William Shakespeare's Romeo and Juliet. And that's what I always use as an example, star-crossed lovers. Now that is a really basic trope that Shakespeare included in his play. Now, over time and over literature and over movies and music, that is a theme that cannot be copywritten. What can be copywritten is if you take that idea and you go ahead and you do your own interpretation. For example, Leonard Bernstein did that with West Side Story. It's about two star-crossed lovers, you know, a Puerto Rican and an American. You have Twilight, you have a vampire, and you have a young high school student. Stephanie Myers has incorporated that trope of the star-crossed lovers and made her own interpretation of Twilight. So I think you get the idea as to what we're talking about. Next thing, I don't know how many of you do cookbooks, but I want to point out that cookbooks are not copyrightable. What is interesting is that, for example, the Copyright Office views recipes as a simple list of ingredients, like a mathematical calculation that's not copyrightable. But what is copyrightable is the artwork and the photographs and the way you have little essays and stories about your grandmother's chili. I mean, it's all of those things that compose the book that makes the book copyrightable and not the recipes themselves. And what chefs do is they borrow from each other. So it's always better to give attribution if you're going to be using someone else's recipes in your book. But I want you to know you're free to do that because recipes themselves are not subject to copyright protection. Also, Your website is not subject to copyright protection. What is protectable is the artwork and the photographs and the blogs and the information that you put up on your website. So for example, if you have photographs, make sure you have that little copyright designation on your stories, on your artwork, on your photographs, to show the world that you know you're protecting your rights in work that is contained on your website. Now, what's great about copyright, as I said before, is that from the moment you start to create it, you have copyright protection. It's automatic. You do not have to register your copyrights. So it's very easy to create. It lasts up to the life of the artist plus 70 years. So it is a right that you can pass on to your heirs. Also, as I said, no registration is required. However, I'm going to show you why it's best to register your copyrights. Well, first of all, there are benefits if you go ahead and register your copyright at www.copyright.gov. The first is that when you get your certificate, it's public notice that you are the owner of that work. If there's ever a challenge, if there's ever any litigation, that certificate and registration is legal evidence of your ownership of the copyright, and it's prima facie valid. That means you don't have to go ahead and prove it. If you're registered, you have your certificate, it is valid. Also, what you should know is that you have there's a 3-year statute of limitations for bringing an action. People always ask me, how long do I have to sue someone for infringement? It's 3 years. But you cannot start an action in federal court or under the case provision, which I'm going to be talking about next, unless your copyright has been registered. It also entitles you to a maximization of damages, which means that you can get your cost, your fees, your disbursements, your interest, punitive damages. There's a whole list of damages that you're entitled to because you have registered your copyright. And as I said, it entitles you to go ahead and use the new case registration. Now, what is case registration? Well, not everybody is J.K. Rowling and is going to sue for hundreds of thousands of dollars for infringement. If you're a small guy like you, like me, we may not have damages that exceed $15,000. So in the Comprehensive COVID Surplus Act that came through in December of 2020, the Copyright Office inserted a new statute, and it's kind of it's an accelerated way for smaller people to pursue copyright infringement. It's called the Copyright Alternative in Small Claims Enforcement Act. It creates a 3-member tribunal, and you can go ahead and you submit your papers on the website to this tribunal. Once they determine that you have a case going forward, they basically prosecute it for you. Now, just looking at in terms of comparing it to going to federal court, you need $500 just to get in the door to file at federal court. You're going to need an attorney, and it's going to be a very expensive and long procedure. The case, from soup to nuts, your fees are $100. It's $40 when you apply. If they accept your case and determine that there is infringement, it's another $60 for you to proceed and go ahead. If you're interested in finding out more about that, you would go to ccb.gov. They just started accepting cases in April, so they're very new. They've got rules and procedures, but you don't need an attorney. It's something that you can do yourself. It's a very streamlined procedure. And I have here like a little map that shows you file your claim, they review it. If it goes ahead, it's very, very simple. It's like 5 or 6 steps for them to go ahead and help you file your claim. And it's done within 90 days. You can get get a resolution. Very quick, very clean. So as I said, there are certain benefits to registering your copyright. Where do you register? At copyright.gov. How much does it cost? $45 to register your copyright. You can do it either by snail mail or go ahead and do it on their website. I always recommend that people file on the website because even though it's going to take a while for you to get your copyright certificate, you have that receipt showing that you've gone ahead and you've filed your application with the Copyright Office. So you've got something that's timestamps to show that you've applied. Now, what's also really nice is that there's a new procedure that allows you to lump together works and file them as a group. And it's designed for people who post on the internet in a 3-month period. If you've posted works that are 17,500 500 words or less, and they've been posted within 3 months, you can lump them all together, whether it's a blog, let's say they're photographs, and that is $65. That's a group registration. The turnaround time for getting your certificate, even before COVID, it was about 12 months, which is why I suggest people get that receipt and file online. But the place to go is www.copyright.gov. Now, what I also tell people is this is the proper form for designating your copyright. It's C with a circle, the year 2022, and your name. Mine's Jody Susan Millman. Now, that should be on all of your works. Before you send it to a publishing company, before you send it to an agent, before you enter it in a contest, on your title page, down at the bottom, put your copyright. Some people say, oh, that's not professional, but you know what? It protects your rights and helps prevent anybody from infringing on your work. Now we're going to switch over to trademarks. We're going from the artistic realm to the commercial realm, because trademarks provide protection under the Lanham Act, which is for the flow of goods and services in commerce. A trademark is a logo. I mean, we see them all the time. If you look at my examples here, we've got Oreo cookies, Levi jeans, we have Canon, we have VW, we have Pop-Tarts. Those are identifiable logos that are in the flow of commerce that specifically identify a good. The same thing is true for a service mark. A service mark represents a service that's in the flow of commerce. For example, FedEx, they don't really sell anything, but they're a service. Google is a service. UPS is a service. They're entitled to service marks. Now, for example, as a crime fiction writer, I belong to Sisters in Crime. And they have, if you look above the little E, they have a registered service mark and trademark. So here are the designations. We have R with a circle for registered trademark, TM for unregistered trademark, and SM unregistered service mark. Now, what does a trademark protect? Well, first of all, characters, and we're going to talk about that in a couple of minutes. The title of a series. So for example, Diana Gabaldon writes a series, the Outlander series. She could go ahead and she could get protection for the Outlander series, but she could not get protection for the first name of her first novel, which is Outlander. So it has to be for a group or a series, like the Game of Thrones series. I mean, I think you get the idea. Distinctive logos, we've already talked about that, with Quaker Oats and Pop-Tarts and VW and Oreo cookies. Also distinctive costumes. So there's some people who go to Comic-Con and create these elaborate costumes, or look at Broadway with their elaborate costumes, like in Wicked. Those are the type of things that are subject to trademark protection. We're switching from commerce to science. The third leg of our intellectual property, we've done copyrights, we've done trademarks. Now we're going to talk a little bit about patents. Patents are also protected under the law, and they're much more restricted than copyrights, because they're only good for 17 years, and they're only good for territorial lands of the United States. There's no worldwide protection for specific patents. Now, a patent is a protection for a scientific invention, and there are 3 types of patents. There's a utility patent, which is, for example, a mechanical device or a chemical process. Those things are protected by what's known as a utility patent. A design patent I describe as creating a better spoon. And for example, I use this example of a butter dish. I was looking for a butter dish and I went on Amazon and I found this. And you see it's a butter hub. It's got, you know, little legs and it's got a magnet on top for the little knife. And I don't know if you can see it, but it's a patent pending. So what these people have done is they've created a better butter dish and they've applied for protection to the US Patent and Trademark Office. Also, the third category is plants. So if you create a special asexual orchid or roses, anything that is asexual, that can be subject to protection under the patent laws of the United States. So you see, we've done intellectual property, we've done copyrights for the arts, we've done trademark for commerce, and third, we've done patents for science. And patents, you're going to need an attorney to represent you when it comes to patents, because they have to be admitted to the patent bar in order to submit an application. For a trademark, you can go ahead and obtain protection and registration under the US Patent and Trademark Office. However, I'm going to give you a hack. And the hack for that is that most states, through their Department of Secretary of State, allow you to register a service mark and trademark on that state level. That's going to cost you $50. If you go to the state, it's going to be at least $350 to $500 for you, again, just to get in the door to file your registration. And it's quite a complicated scheme of things. So my suggestion is you go, if you want protection, you go to your Secretary of State, you file there, and it's one and it's done. Now we're going to return to copyrights because there's a lot to discuss as far as copyrights are concerned. We're turning now to the public domain. Now the public domain means that a copyright has expired. As I said, the life of a writer or an artist plus 70 years. That's if a work was created after 1978. Before that, under the prior law, copyrights are starting to expire. Every year on January 1st, it's called Public Domain Day. And what that means is that a new crop of works enter the public domain. That means if you want to use them, you want to copy them, you want to reprint them, you want to do anything you want with them, you do not have to get permission from the copyright owner, and you do not have to pay royalties. They're yours to use free and clear. This year, 2022, works prior to 1925 entered the public domain. And I'm going to show you some examples that are in the class of 2022. And you're going to be shocked at what you're going to see here. Now, first of all, Winnie the Pooh entered the public domain. I'm going to talk about Winnie in a minute. Ernest Hemingway's The Sun Also Rises. We have T.E. Lawrence, The Pillars of Wisdom, which was the basis for Lawrence of Arabia. Bambi entered the public domain. Agatha Christie's The Murder of Roger Ackroyd. All of these incredible works entered the public domain, which means if you want to reprint them, you want to use them, you want to use their characters, you're free to do it, no charge to you. Now let's talk about Winnie the Pooh, because that creates a really serious question and conflict between trademark law and copyright law. Well, Winnie the Pooh, as I said, entered the public domain this year. That means the characters of Pooh and Tigger and Piglet and Christopher Robin and the 10 Mile Wood, all of it entered the public domain. So if you wanted to go ahead and reprint those books, the original works, you're welcome to do it. However, let's talk about Disney for a second. Disney has co-opted Winnie the Pooh. And what it has done is it has added other adventures that were not part of the original story. So Disney is entitled to a copyright on those derivative works, anything that it has added originally to that underlying work. It has also gone ahead and created its own Winnie the Pooh and created its own little trademarks that last beyond A.A. Milne's copyrights. And Disney is going to be very, very aggressive in litigating anybody who steps on Winnie's toes. And the reason is because in 2024, their major property, Steamboat Willie, the grandfather of Mickey Mouse, is entering the public domain. And so right now, Disney is working very hard behind the scenes to try to get the law changed so that Mickey doesn't go in the public domain. So as you can see, there's a tension, and this is something that as a lawyer, I just love to see what's going to happen, a tension between a copyright that expires and existing trademarks. And it'll be interesting to see what Disney does. So for example, let's talk about how you can go ahead and use somebody else's expired copyright. Well, in 2021, another famous work entered the public domain, and that's our friend here, the Great Gatsby. So if you wanted to go ahead and print a t-shirt that said it's better to burn out than fade away, you're welcome to it. Or Blowing in the Wind, you could print a t-shirt that has the lyrics for Blowing in the Wind. They're free, they're open to the public. Now, the flip side of public domain is what's known as fair use. Fair use means that a copyright exists on a work. However, you're able to borrow and use it and incorporate it into your own material. However, there are several provisos. First of all, your work must be for nonprofit, educational uses, parody, or criticism. You can't just, copy it for the sake of copying it. And this is an area that gets litigated quite often. So the courts have come up with 4 criteria that it reviews in order to determine whether something is fair use. For example, as I said, was the portion borrowed used for educational purposes, news reporting, or criticism? If it is, it's fair use. The nature of the copyright, is it factual or creative? Generally, if it's factual, it's okay. It's easier for the court to consider it as being fair use. Again, how much of this was borrowed? You can't plagiarize somebody's work and claim that it's fair use. And this is where teachers sometimes get into problems because they'll create their own workbooks and they'll go ahead and sell them to their students. They technically can't do that. If they've had the entire Robert Frost poem going into the woods on a snowy evening, or something that's still subject to copyright, that is not permissible. It can only be a small portion. And the 4th criteria, it cannot diminish the economic value of that underlying copyright work. Now, as I said, it's got to be for criticism or parody. And here, for example, our little Charlie Brown is a good example here of parody. I want to give you some examples of fair use because I think these really drive home what I'm talking about. Well, first of all, there was a DJ, and what she did was she took a bunch of other songs and she mashed them up and made her own musical composition. The courts held that yes, she could do that. That was fair use. There was a guy who played video games, which are subject to copyright, and his friends would take a video of him performing, tricks and doing all kinds of crazy things while he's playing these copywritten video games. The court held that that also was fair use. Think about Ken Burns, his wonderful documentaries, whether it's about the Civil War or it's about Muhammad Ali or the Holocaust, he is borrowing works that are copywritten and he's stringing them together to make documentaries. Now, people say to me, oh, he gets paid for that. No, he is a nonprofit and he gets grants to help him produce these works. So think about Ken Burns. He is a perfect example of fair use. Another really good example is a gentleman named Shepard Fairey. He's an artist, and you may not recognize his name, but you'll certainly recognize his work. He is the guy that created the Hope Obama poster. And you see we have the photograph here of Obama. This was taken by the Associated Press And they saw that Shepard Fairey was, making oodles of money on posters, on postcards and calendars. And they said, hey, that's our image. This is, you have infringed our copyright on our photograph. And Shepard Fairey said, oh no, that's he was newsworthy. It's fair use. I can go ahead and use it. A third party popped up, a guy named Manny Garcia. And Manny was the photographer who took that actual shot. And he said, hey, that's my photograph. I'm entitled to some of the goods and some of the treasures that Shepard Fairey is accumulating. Well, the court held that Manny Garcia was a work for hire. He was not the author. He was a stringer and a freelance reporter who sold the photograph to the Associated Press. And as a result, he had no rights or claims to any royalties or any rights from this work. Ultimately, in 2011, the AP and Shepard Fairey reached a decision where they decided to split the proceeds of any money going forward. And I don't have a slide for it, but the poster was almost a remake of a hand-painted oil painting of Obama that Shepard Fairey made. I think it was in 2007. In May this year, that oil painting went up for sale at Sotheby's. They listed the value between $300,000 and $500,000, and it sold for $725,000. So you see that underlying work did create some economic value to this Hope poster. And as a result, you can see why the Associated Press was really interested in pushing this issue about fair use. Next, we're going to talk a little bit about defamation, because that's something that writers have to be aware of. And as we know, over the summer, we were like batted over the head with defamation. And you'll see what I'm talking about in the next slide. Well, first of all, defamation is when you say something that you know is wrong about someone. If you say it, it's slander. S is for slander. That would be a speech. That would be a newscast. That is slander. If you put it in writing, if it's a magazine, on the internet, a blog, an article, that is libel. And writers have to be very keen about not defaming any person that they mention in a book. And people ask me this all the time about memoirs. Can I mention thus and so and say bad things about him? The answer is no. You can only say things that are public knowledge. You cannot reveal any secrets. But I'm going to talk about that in a second as well. Now, we all know about the trial of the celebrities, the grand he said, she said that, was in the news 24/7 over the summer. Now, this is a really interesting study in defamation, because you have two celebrities. You have Amber Heard, who wrote an opinion in I believe it was the Washington Post, claiming that she had been abused, had an abusive relationship. She never mentioned her husband's name, but everybody knew she was married to Johnny Depp. So he claimed that she was defaming him. So he went ahead and he sued for $50 million. She countersued for $100 million. And as you can see, he won 15 and she won $2 million. Now, I really think that this case raises some serious questions. The underlying case here is a case called New York Times versus Sullivan, which was decided in 1964. It held that a public official or a celebrity is held to a higher level of proving defamation. They must show actual malice. And what that means is that you know a fact is wrong, but you say it anyway. So for example, Amber Heard Depp claimed she was not in an abusive relationship, but she said she was anyway, and she put it in writing. Now, that is all covered by the First Amendment. And as I said, it raises a lot of questions. First of all, does the First Amendment give too much protection for defamatory speech? Should public officials and celebrities not have to prove this actual malice? Should they just have to prove that whatever was said about them was false? In other words, were careless and false statements on the part of a defendant enough to give rise to defamation? I have to question whether in this particular case, whether this case was really designed just to stir the rumor mill. Was this a publicity stunt, a very expensive publicity stunt? Were either one of these people seeking the truth, or were they really just trying to get more likes and follows and retweets in their social media? And finally, would success, because both of them really won in this case, they both ended up getting money out of this case, does success remedy the reputation of either of these parties? Or from now on, are all of us in the public mind still going to think that these people are crazy? I think that's what it comes down to. Raises some really, really interesting questions. It also raises questions because this is something that I have to deal with as a writer. When you write a book, I write stories about that are inspired by Hudson Valley crimes, as opposed to being based on actual crimes. And here we've got a slide that shows the difference. For example, based on is a book like In Cold Blood. Truman Capote mentions the name of the defendant, mentions the name of the family that was killed, mentions the name of the two killers. It was a creative, nonfiction retelling of the story. The same thing with Devil in the White City, which is talking about a serial killer during the Chicago World's Fair in the early 20th century. It was in the 1900s. They're relying on facts. They are specifically retelling the story. Now, inspired by is different. Inspired by is, for example, the Paris wife. She is painting a picture of Hadley Hemingway and Ernest Hemingway and their tumultuous relationship. In that she drafts big characters, so you don't know where the actual Hemingway ends and the fictional Hemingway begins. I do the same thing in my book, Hooker Avenue. I'm going to talk about it a little toward the end of the program, but my story is inspired by a serial killer that was abducting and killing women here in my hometown of Poughkeepsie. 8 women disappeared over a period of 2 years. I'm inspired by the seedling of that story, and I created my own cast of characters. So it's not really the defendant, it's not really the prosecutors, and it's not really the victims. So you see the difference. And especially if you're a writer, you have to be very careful if you're doing based upon, because as I said, if it's based upon, you can only tell what's in the public. You cannot reveal any secrets unless you want to open up yourself for defamation charges. I'm going to shift gears now because I want you as writers and artists to have 2 hats. One is the creative hat, and we've talked about that. We're going to talk about that a little bit more, but also you have to be a business person. You have to go ahead and decide what kind of protection or what kind of liability you are subjecting yourself to. So, for example, are you just going to be an individual? Are you going to be a limited liability company, which you have to file with your Secretary of State, a corporation, which allows you again to file with the Secretary of State, but allows you a broad protection and umbrella against liability, but it also allows you to issue shares to your family members. Because remember, as I said, copyrights last for your life plus 70 years. Or a partnership. Are you writing with a buddy? Are you a children's writer who's working with an illustrator? Are you a co-writer of a book? So do you have a partnership agreement? Have you and your partner set out the rules so that in the event you break up or decide to do other projects with other people or by yourself, what are the rules governing that relationship and the royalties going forward? So you really have to put on your hat and think, what is my liability here? Now, for me, I've got more than one book. I have nonfiction books because I do a Broadway guide. So for me, I felt it was best for me to do an LLC. So the name of my LLC is JS Millman LLC. So now exactly, what do you have to think about when forming a company? As I said, limiting your liability, especially in the area of defamation. And there are attorneys who you can pay to vet your books for defamation. And to find them, I suggest you contact the Writers Guild, because the Writers Guild has an archive of programs, and one of them was on vetting your artistic property for liability and defamation. Again, if you form a company, an LLC or a corporation, you have an umbrella that protects your assets. And again, if you form a company, you have to sign every contract in the name of that company. So let's say that you are writing a book and you've got a company and you're hiring an illustrator or a photographer. Any contract you have with that person must be in the name of the company. When you sign a publishing agreement, must be in the name of the company. And as I mentioned, your LLC and your corporation are filed with your Secretary of State. Now we're going to shift again to a publishing contract, which is really an exciting thing which happens to you. Now, what is a publishing contract? It's basically an outline of the rights and duties that you as an author owe your publishing company and vice versa, what they owe you. It's a binding agreement. It clarifies the terms and conditions of your relationship and also provides for ramifications in the event that there's a breach. Now, what are some of the key provisions? This first slide is about the author's obligation under the contract. Now, what is the work that's being published? Is it going to be one book? Are you committing to a series? Is it exclusive? Could you go ahead and do work with a publishing company and then go hybrid or publish something else on Amazon? Is it so extensive that it includes any works that grow out of the characters that are created in your book? When you sign a contract, you have to determine what is the work that's being covered by this agreement. And what rights are you granting them? Those are called subsidiary rights. Are you giving them audiobook rights, foreign rights? Are you giving them rights, book club rights, television and film rights? What rights are you granting to them? Now, again, what is the territory? Is it going to be the United States? Is it worldwide? Is it English-speaking languages? All of those things are set forth in that agreement. Also, as I said, is it exclusive? Can you go out and do a work with another company? Can you self-publish? What can you do? How binding and how tied up are you in this agreement? And before you sign the agreement, you really have to think, is this a long-term relationship I'm establishing with this company, or is it short-term? Those will all determine the works that are being covered and the grant of rights exclusivity. Also, when is your manuscript delivered? What are the dates? When you get a contract, you'll find that there are certain delivery dates that are set forth in the contract. Can you build yourself in some wiggle room? So all of a sudden you find out that you're expecting a grandchild, or you're expecting a child, or your kid's getting married, and you can't deliver in time. Are there certain, do you have wiggle room so that you can deliver your manuscript late without being held in breach of contract? Also, who's going to own the copyright? When you see these contracts, well, first of all, they're all written in favor of the publisher. They're never written in favor of the author. And publishing companies expect you to go ahead and revise them and negotiate. Now, you're going to see in this contract that a provision that's going to say that on behalf of the author, the publisher will apply for a copyright. No, no, no. You go ahead and right before you send it to the publisher, you're going to send it into the copyright office and get that registration. So by the time you send it into your publisher, it's a done deal. You've got your copyright registration. What I also recommend to people is that as you go through this publishing process, you're going to have developmental edits, you're going to have copywriting edits or copy editing edits, line editing, and you're going to be reviewing the final before it goes to print. What I suggest people do is, again, file a second copyright for that work. You have one, the original work, and you have the second work. And so that's going to give you a derivative work protection on anything that was subsequently added to that original contract. Now, what are some of the publisher's obligations? Well, first of all, they've got to tell you how and when the publishing is going to occur. You want to have a publication date in there. And generally, it'll say within 12 months of the date of this agreement. Now, you want to make sure that's in there. However, during the pandemic, this created havoc because there's another paragraph that's going to be in there that's called force majeure. In the event that there's an act of God or war or some type of natural calamity or disaster, they have the right to extend the contract. But you want to make sure also that there's a deadline in the event that they enact this force majeure, because they found during COVID, books by Stephen King were getting delayed. Tons of books were getting pushed back because publishing offices were closed. There was a shortage of paper and just things were just not operating as they were. People weren't in the office, so things weren't getting done. So you want to make sure that the company is on a leash just as much as you are, because you don't want to plan on having a book come out in 2022 or 2023 and have it not come out till 2023 or 2024 or 2025. So you want to make sure that some kind of deadline is in there. Also, royalties. Now, you want to make sure that royalties are in there. And the next slide we're going to talk about, we're going to come back to those other items, but royalty schedule will be in your agreement. And generally, a author receives between 10 and 15% for a hardcover book. And so people always ask me, how much am I going to get? Well, first of all, if it's a hardback book, you're going to get a 15% royalty, which means that you have the opportunity to earn $4.20 per book. Now, that means if they tell you there's going to be a run of 5,000 books, which is a print of 5,000 books, you have the potential to earn $21,000. However, if they give you an advance of $10,000, an advance is a lump sum payment that is paid to you. It's usually broken up when you sign the contract, when you reach certain benchmarks in the publishing, in the manuscript review process, and when it's given for final submission, you get the final payment on these monies. Hopefully, you will make sure they are non-refundable. Those are monies that gets balanced out against your earnings. And so you would have to sell about 2,300 books in order to earn another penny on your royalties. And if you look at these charts, you can see how inequitable the whole situation is. Because if you have a hardcover that sells for $28, $14 is going to the publisher. Okay, you see that in the yellow. The price is $28, $14 is going to the publisher. The rest is going to the distributor and the retailer. That's who's getting the cut. So the smallest amount of all the money, whether it's an ebook or whether it's a hardback book, is going to the author. And if you look at these bar charts over here, you'll see, for example, the same thing. The author's royalty is blue down at the bottom. The production cost is red. The distributor, which is a group called Ingram, or it could be Amazon, they're getting the biggest cut of the pie here. And the profit and the publisher is up top. And you can see we really don't make a lot of money, but we're doing it for love, right? We're not doing it to make money. But those key provisions in your royalties, and royalties are also going to change. You know, for example, if it's foreign, if it's TV, if it's television or film or a book club, all of those different royalties are set out in your agreement. Now, also advertising and promotion. If they promise you that you're going to take an ad out in the New York Times or in any type of Time magazine or People magazine, you want to make sure that that's in the agreement, because unless it's in writing, it disappears after you've signed the agreement. And also you can think, if you win a national prize, you should get some kind of bump or bonus in the event that that happens. Now, contract also outlines the grounds for termination of the contract. For example, you as the author don't deliver your contract, that the publisher doesn't publish within a period of time, or they fail to pay you your royalties. That's another reason why a contract will be terminated. Some other additional provisions to keep in mind is the right to revise your manuscript. For example, you don't want to submit a final version or a version that's about whales, and then the book comes out and you find out it's about sea lions. You want to make sure that you have the right to revise your manuscript. Also, you want the right to have some kind of meaningful input into the cover of your book. You may not get approval of the cover, but you want to make sure you get approval of the title of your book, and you want to be able to approve and sign off of the interior design of the book. You also want the right to audit them to make sure that you're getting paid the royalties to which you are entitled. And as I said, you want control over editorial changes. You don't want to submit a book, as I said, that's about whales, and the next thing you know is about sea lions. Also, and this is a key provision as well, defining out of print, because contracts generally terminate when a book is out of print. Now, we all know with ebooks, books don't go out of print anymore. They live on in digital life. So you want to make sure that you say within 6-month period, X number of books, 100 books aren't sold, and that will be determined as the benchmark for being out of print. So you're going to see that in there, but make sure you put parameters on it that allow you to get out of the contract. Because when you get out of the contract, you get all of your rights back. You can go to another company, you can publish yourself. And also, when you're getting your royalties, you want to make sure that the company isn't ripping you off in deducting other things out of your pittance of a royalty. You know, they're going to deduct things like printing, and they're going to, do the phone and postage, but you don't want them writing off their jets out to New York to go to the book fair. So you want to make sure that you understand what they are deducting. So some do's and some don'ts. Well, first of all, do know your goals as an author. Do know whether when you enter into this contract, are you doing a long-term deal with them, or is this a short-term relationship that you're going to have with them? Read the contract carefully. Now, you're going to read it. It's not going to make any sense, but I'm going to give you 2 hints. First of all, if you join the Authors Guild, and I think it's about $125 a year, they will review a contract for you for free. They will also, on their website, have what's known as the model publishing contract. And paragraph by paragraph, they explain the legalese in plain and clear language that you understand what that contract means. You can also contact the Volunteer Lawyers for the Arts. It's a national organization that represents artists. You can also contact your bar association. They may be able to refer you to some attorneys who do this for a living, who are publishing law attorneys. But make sure that you've read the agreement anyway before you talk to anybody, so you can have an intelligent conversation with your publisher, with your representative, or your agent, because your agent's going to know everything about the contract. And also, when you get that contract, after you've negotiated with them, make sure that the changes accurately reflect everything that you've agreed upon. Because as I said, once the contract is signed, if it's not in black and white, it does not exist between you. Again, remember, the contract is drafted in favor of the publishing company. So they're expecting you to revise and negotiate on your behalf. Don't think it's written in stone. Don't think they'll pull the contract away from you. They won't. They expect you to change it. And finally, once it's signed, keep it in a safe place. Keep it with your copyrights. Keep it with the deed to your house, your insurance policies, the titles to your car. It's a very valuable document. Keep it in a safe place. So what are the don'ts? And they're really just the flip sides of the do. Never sign an agreement without reviewing it. Common sense. Get everything in writing. Common sense. Never assume any terms are agreed upon unless it's in the contract. And do. Contact a lawyer or have your agent review the contract for you. So here are some resources that I want to share with you. And as I said, we know that if you want to register, you're going to go to copyright.gov. If you're more interested in fair use and you want to know a little bit more about it, you can go to stanford.edu. And they also have a list of, they have a really good description and list of what is fair use. The Authors Guild, I cannot sing the praises of this organization enough. You know, not only will they provide a free lawyer for you, they'll design a website for you for free. They have symposiums. They have a monthly newsletter. They really keep you up on the news regarding publishing. And they're the only organization that lobbies for artists' rights in Washington. So again, it's really worth it to join them. If you're interested in what's in the public domain, going back to copyright, copyright also has, I want to mention this, a database of every copyright that's been applied for. So if you want to find out whether a book has is subject to copyright protection, you can go to copyright.gov. And what made me think about that is that Duke.edu, it's their law school at Duke. They also have a database of everything that's in the public domain. And public domain, I don't know if I said it before, applies not only to books, but it applies to music and film and and artworks. So for example, there's some works by Edward Hopper that are in the public domain. I think Birth of a Nation, the movie, is in the public domain. So if you're interested in that, go to them. It's really cool. They've got a really nice database. And as I said, we're coming up on January 1st. And so there's going to be a whole slew of new works that are going to enter the public domain. Also, you can go to Volunteer Lawyers for the Arts. As I said, they provide free representation for writers and artists who have legal issues. And I've written more intensive blogs about most of these subjects on my website. So if you're interested, you can go to my website, which is www.jode, J-O-D-E, Millman, M-I-L-L-M-A-N.com. Now, before I finish, as a lawyer, I have to mention that what I presented to you today is really for educational purposes. It's not my intention to provide legal advice. I'm here to provide general information to help give you pretty much an overview of your rights. And I've also prepared a handout. So if you email me at jodysusanmillman@gmail.com, and when I escape this and we go back to the question and answer period, I'll put my email in the chats for everybody to have. I have a handout. I'm really happy to email it to you, no problem. You can follow me on Goodreads at Jody Millman. I'm on Instagram at Jody Writes, and my Facebook is Jody Susan Millman, author. And before I close, I wanted to give you a little idea about really who I am and what I write about. And as I said, I'm an attorney. I practiced many, many years here in Poughkeepsie, and I have always been interested in the local criminal scene. And I practiced matrimonial law and copyright law and real estate, personal injury. I did a little bit of criminal, but being in Poughkeepsie, for some reason, we had these really crazy crimes occur. And two that I'm going to tell you about literally landed on my doorstep. In April of this year, my book Hooker Avenue came out, and it was inspired by a serial killer named Kendall Francois. And Kendall was actually soliciting and picking up women, prostitutes who were hanging out on the front steps of my law office. In 1995, I purchased the building with a partner, a law partner, and the building had been empty for many, many years. We purchased it from a bank at foreclosure. And the women would solicit their clients in front of our building and take them over across the street to an abandoned parking garage and do their business. Well, Francois was coming by and picking up these women. And we were having a problem when we started and we opened our practices there, because these gals were literally sitting on the doorstep and they were harassing our clients. So we were calling the police and saying, please do us a favor, can you move these girls along? We don't have any problem with the girls, just move them along. And gradually the women were disappearing. So in 1995, we buy the building. From 1996 to 1998, he's picking up these women outside of our building. And he's taking them to his house, which is 4 blocks from where I live. I mean, Kendall Francois was a guy who participated in our community. Everybody knew him. He worked at one of the local school districts, very quiet guy, and he was killing them and burying them in his house. So to me, I took the seedling of that story and I created a story that has my character, Jessie Martin, who's an attorney, at odds with her friend who's a detective, who is searching out these cold cases involving missing women. And Jessie saves the life of a woman who has escaped from the clutches of this gentleman, of a suspected killer. And through this woman, her name is Lissy Sexton, the 3 of them, Lissy and Jessie and Ebony, go ahead and catch a serial killer or on the hunt for a serial killer. Then the new book, which isn't really so new, it originally came out in 2019 and was recently released on October 11th by my new publisher, Level Best Books, is called The Midnight Call. And again, I was inspired by a local crime by which I was personally touched. And it turned out that in the 1966 to 67, I had a teacher named Albert Fentress. And he was one of the most popular teachers in town. He taught world history. I mean, almost every student went through his classroom. And he was the kind of guy that when you go back to visit your high school, you'd go to visit. Because when we were in class, he would, if we were studying Robert E. Lee, he dressed up like the Civil War. If we were studying China, he dressed up like Genghis Khan. We would have these elaborate Indian feasts. I mean, he really was an engaging history teacher. That was in 67, 67, 68, 69. I come home from law school in 1979. And in August, I open up our local paper, the Poughkeepsie Journal, and there's the headline, Teacher Held in Teenagers Shooting Death. He was accused and ultimately found guilty of randomly killing a teen who was trespassing through his yard. And again, I took that seedling. This was really the first book in the series. The seedling of a woman who's pregnant, an attorney named Jessie Martin. She gets a midnight call in the middle of the night from a teacher who says, I've just killed someone, I need your help. And Jessie rushes to his aid and her life circles down the drain as she tries to help her mentor, this teacher, and ultimately he betrays her. So, as you can see, I am not only an attorney, I'm an author of Queen City Crimes. My books are Hooker Avenue and The Midnight Call. And that is going to end the presentation. Now we're going to come to question time. How are we doing? Are you still there, Jennifer?
I am. Let me get my video started again. If you want to go ahead and stop sharing.
I'm going to stop sharing.
All
There we
right.
go. Okay.
So we did have some questions in chat. So I'm going to start with one of those and then we'll come to in here in the room. Hold on. So the first question was, are there legal ramifications for using names of companies or brands in your book? I've read a few books with restaurant names in them. Do you have to get permission?
You can mention the name of a place, a product, as long as you do not defame them. So for example, you want to talk about a character taking out their iPad or going to a restaurant. And I have a funny story about that. I mentioned a little coffee shop in town called the Crafted Cup in Hooker Avenue. And a friend of mine the other day said, I went to the owner's house of this coffee shop. And he said people were coming in saying, hey, your place is mentioned in this book. So this guy went out, now he's reading the book, and I say some very nice things about his coffee shop. So yes, you can go ahead and mention them as long as you don't say anything bad about them.
Well, I think the funny story that I know is that in E.T., the novelization for E.T., they used M&Ms, but M&Ms would not license the movie to use M&Ms. And so Reese's Pieces would, and that's how Reese's Pieces got to be popular.
There you go. See, M&M's missed out. I mean, come on, Steven Spielberg comes knocking at your door.
Exactly, exactly. All right, do we have questions in the room?
I do.
Okay, ask your question.
I have a lot of questions. A question, if you write a story on a trial, who has the rights of that trial in the true story?
So the question is, if you write a story on a trial, who has the rights on the true parts of the trial?
Okay, well, first of all, it's technically in the public domain because a trial is a public forum. So you can go ahead and use it to your heart's content, except again, if you defame the people or you reveal facts that were not revealed during the trial. So somebody recently asked me a question about that. They were interviewing someone who was found guilty of a murder. And they interviewed him and they were writing a true crime recitation. And he initially gave them his permission to write his story. And they were casting him in a very favorable light. Perhaps he didn't commit the crime. He then changed his mind and then started to make demands. I want to see your manuscript. I want approval. I want this. I want that. Well, first of all, they were smart enough to get his written permission to go ahead and tell his story. And then I said, look, first of all, if you're interviewing a criminal, someone who's been found guilty of murder, by the nature of that person, they are a criminal. So they are not a very reliable person to begin with. So I suggested to them again that they not disparage him. But I think in that situation, you have greater creative lateral ability to talk about a person because they're bad to begin with. I mean, what else can you say about them? They've committed murder. What worse could you say about somebody? Does that person have a more specific question? I hope I've answered it, but if they have a more specific question.
Oh boy. So if the story's it's all there on a trial. So you write the story or you want to film it in a film, a documented film, something. I guess the writer has the rights, or the person that the story is about has the rights.
So if you're using all the facts from the trial, whether you want to write about it or you want to do, say, a documentary film about it, who owns the rights to that work? Is it the writer? Is it the person that the story is about?
Okay, you've got a couple of things coming here. First of all, everyone owns their right of publicity. And a right of publicity means that you have the right to control your name and your likeness. So you could not, for example, make posters of someone, let's say someone during a trial, okay, of any of the witnesses or the defendant, because they have a right to publicity. And that's separate as far as television and movie rights go. Let's put that's number one, your right of publicity. Second is, as an author, you have the right to tell any story you want to tell. That's, your First Amendment rights. You can tell any story you want to tell. That's your freedom of expression. But again, the only parameter would be is that you do not defame the people. And especially you have the burden of accurately portraying that trial and its outcome. So that's the written portion. You have the right to write and create through your own freedom of expression and become an author of that story, okay? Television and film is different because it's a different medium. As I said, everybody owns their likeness. Everybody owns the right to their name and their face. So if you're making a documentary, you just can't barge into a court. You have to get permission for everybody who appears on that, in that film. That's an entirely different animal, entirely different animal.
Yeah, exactly. But if you have actresses or actors portraying the parts, that is different.
So, yep. So instead of it being a documentary, if you're doing it more as a retelling that's more possibly fictional, so you're using actors and actresses portraying, how does that work?
You can do that. I mean, there was a good example. There was Netflix had one on the staircase, and there was a story about a guy, an author in North Carolina, who was accused of pushing his wife down the stairs. And so that was a documentary. And everyone who was involved in that documentary had to sign off and give their permission for that documentary. However, HBO then made a movie about the staircase, which was based on, with the same name of the people and the court and everything. That was a fictionalized version of that tale. They did not have to get permission in order to do that because it's a fictionalized version of that tale.
Did you have a question?
Yes, I had a question about copyright, the group. How many photographs are considered part of the group for that copyright fee of $65?
So if you're filing copyright as a group and you're doing photographs, how many photographs would apply to that group for the $60 fee?
Okay, I don't think that it's measured in numbers. It's measured in when they were the 3-month period within which they were published on the web. So it could be 3, it could be 500. So you have to specifically look at the statute. I don't think it's a number. I think it's the parameters of the time period.
So it's based on when you upload them to the web, there's a 3-month period.
window. Yes.
So everything you uploaded in that 3-month
Correct.
window could be a group.
It can be poems, it can be blogs, it can be anything that's been published on the web within that 3-month period.
And so the group filing is for things that have been published on the web specifically. It's not for anything else.
Correct. Correct.
Right. So those would be so if it was like a photograph for an art show, or maybe several photographs in an art show, you'd have to do the individual copyright for each one of those, correct?
Unless unless you are publishing a book. So for example, if you're in an art show, sometimes they'll do a catalog. You would go ahead and you would copyright the works inside that catalog instead of having to spend the money to do each photograph, because that can get very expensive.
Right, because I got 100,000 pictures.
Yeah, so it's all dependent on how you're doing it. Yeah.
And I would recommend, people often ask me, down in the corner, I would put a copyright. Whenever you do a photograph, put your little copyright on it. And I tell people that if they're painting a canvas, they can put it on the back. You know, you put it on the back of the canvas. It's not necessary that, because people eventually are going to take it off the wall. But with a photograph, generally, you know, you're displaying it in such a way that you want it on the front of your work.
All right. We have time for one more question, and we've got one more in the chat. Yeah, because the library's closing in 10 minutes. So,
Okay.
all right. So this is going to be the last question. It's from online.
Can we send questions to her? Or?
Yes, she gave you your email address. You certainly can do that. So that was a question of, they have your email address. Can they send questions to you? And I said,
As long
yes.
as long as it's just a general question, not anything that's specific, because I'm not going to be giving any legal advice.
Right. All right. Okay. So here's the last question. Is writing a literature review required for nonfiction or for fiction only?
I don't understand what they mean by a literature review.
Are we talking about, so for the person who put that in the chat, are you talking about like a criticism and how that falls in under fair use?
Yeah, I don't really understand the question. Let's see.
Okay, yeah, so secondary works like theses, dissertations, and writing summaries. So are those copyrightable?
Is a literature review. So is the question, is a literature, is a thesis copyrightable? Definitely. If that's the question, definitely. If it's contained within a literature review, like an anthology, my suggestion is always that you get a copyright on anything you submit to an anthology or literary review, because you are still the owner of that copyright. You're really just entering into an agreement to allow them, for whatever reason, for, you know, educational purposes, or sometimes people do it for fundraising. Groups will ask for writers to submit short stories. You're still the owner of that short story or that, you know, thesis. So you should copyright them. I hope that answers the question, but I think that's what they were asking.
Yes, so I want to thank everyone for coming. If you would like to purchase a copy of Jody's book, Hooker Avenue, you can find copies at our local independent bookstore, The Dock. On the screen here, I have their contact information. And you can actually order through their website, or you can contact them in person or over the phone. We did record this presentation, and we've also recorded some of our previous writers' workshops, and you'll find them on our YouTube channel. If you just go to the library's YouTube channel and search for writers' workshops, they're all in a playlist. It will be about a week before tonight's presentation is posted. And if you subscribe to our YouTube channel, you'll get and turn on your notifications. You'll get notifications when we upload new videos. And our Writers Workshop series will return in 2023. So please keep an eye out on our website calendar at fortworthlibrary.org for more information. And thank you very much, Jody, for your time tonight. It was great, and we really appreciate it.